Committee this Friday morning, January 23rd, and we're taking some additional testimony on H589, and we have three witnesses this morning. This afternoon, we'll be returning to H627 and 626, but let's get started. We have our first witness, Tim Frost. If you could join us.
Sure.
If you could join us at the end of the table, that'd be great. Yeah. And thank you very much for being here on such short notice as well. Thank you. And if you just identify yourself for the record, then
Sure. Good morning, everybody. Happy to be here. Thank you for allowing me to come in and testify and share my story. I'm Tim Frost, and I'm the founder of Peregrine Design Build. And we're a company that does design build, primarily performs residential construction and design services. And the company is based in Burlington. And I retired in 2024 and transitioned the business to two of our employees who are running it now. The company was founded in 1988, so we've been in business for 38 years. And the company performs between 30 and 40 jobs a year in the remodeling business. So we've done probably in the vicinity of 1,000 jobs over the company's career. And we've been sued once in that time, and that's an action is currently in process. And I just wanted to say that I believe that the consumers have the right to be protected against construction defects. I think that's all fair, and that should be some statute to address that. However, I think that the protections need to be fair for both parties and understood to manage expectations properly up front, so that we both know what we're getting into. And I think the homeowners also need to understand the need to implement regular maintenance on their homes, and ensure that small maintenance items don't evolve into larger projects as time goes on. I also feel that reputable companies should be addressing legitimate issues that come up for their clients without litigation, and that's what good companies do. Stand behind their work and take care of their clients, and that's what we've done over the years, and how we've operated and become successful. So today, I know that we're discussing a possible statute change, the bill 589, and trying to arrive at what's the reasonable number of years for a statute of repose. As you know, currently there's not one in Vermont, so I just have a good example, a case study for you to understand of kind of the current situation that we're in. So I can just kind of run you through the brief outline of that, just to give you an understanding. So Peregrine Contracting was contracted to do a large whole house renovation back in 2002. The project started in 2002. We partnered with Truex Collins and Partners. We did the construction. They worked with the client on the design. And so just for not disclosing the owner's names, I'll call them the Smiths. And we finished the job as an 18-month project. So we achieved substantial completion in January of 2004. And I know you guys were talking about substantial completion. For us, that's a formal process that's written into the contract. So you have a final payment that's in the contract that specifies that you'll be paid that payment at substantial completion, minus whatever is left for just some punch list items. So you might have you'd be paid your final payment. That's maybe a couple $1,000s for a list of items that you sign off on, maybe some paint touch up or a couple of light fixtures or something like that, just so there's a formal process. And then when you finish that, you get to rest your money, and that's the job's 100% complete. But it's substantial.
Yeah, we have a quick question, I think, on that.
Yes.
Thank
you.
I have, but
For sharing that, 'cause it's something that we covered yesterday.
Uh-huh.
When there is a multi, what is the word for it? Phased project, is that spelled out in the contract too, of like, we hit the substantial completion for this part of it at this date? That was the question I had, of when there's the multi-phase project.
Right. I guess an example would be a client that's engaged with us over the years. Maybe we've done 6 different projects for that client over the years with incremental renovations on their home. But each contract would be a separate contract for that scope of work. So it might happen this year, and you would have that process where you would have the substantial completion would be signed off. So that phase would be completely done. So maybe 2 years down the road, you may have done a master suite last time. Maybe they want to do their kitchen next. So then the kitchen renovation is a separate project. So if there was, I think you could easily separate out which if it was a defect, which project the defect happened under.
right, thank you.
So since January 2004, the project was complete. The Smiths sold the house on 12/20/2020 to the Hills, we'll call them, as hide their names. That was 17 years after the substantial completion of that project. And on 2/13/23, 2 years after they purchased the house, the Hills discovered a water stain on the kitchen ceiling. I know you guys spoke about examples of water on the ceiling yesterday, possibly. That was 19 years after substantial completion. And they hired a contractor to investigate. They discovered that the roof above was leaking somewhere. And there was also a roof deck as part of that construction on top of the single-story roof over that kitchen area. The Hills contacted me and asked me if I would look at it. My observations were that the deck was poorly maintained and had extensive rot. The deck posts were rotten, and they had the cracks in the posts, and it was seemingly obvious to me that water was infiltrating down through those rotten posts. Hills disagreed. They said that the damage was a design issue. The roof didn't have enough pitch, and there was poor workmanship. Thus, we disagreed, and they thought that I could do the repairs at no cost, which I was not willing to do. And I tried to get them help from another contractor, which they didn't take up my assistance on that. The Hills ended up suing the Smiths to secure an assignment of the original contract with them. So this allowed the Hills to be parties to the original construction contract against Peregrine. And so in June or July 2023, the Hills sued Peregrine for trying to get us to be responsible for the what they saw as our defects. At that point, I engaged our insurance company. We have a liability policy, and they engaged their attorney. And so now 2.5 years later, the case is still ongoing, and it's set to go to trial when that could be scheduled. Excuse me. To date, there's been about $31,000 in attorney's fees that we've incurred to defend ourselves. And then on a side note, Mr. Hill, he went to law school, so he's representing himself, so he's able to prosecute us with little expense. And they also have 3 other lawsuits going on, and they also sued the contractor who ultimately ended up helping them on the job. So for us, risk management as an ongoing business is typically addressed with a liability policy, which carries coverage for these sorts of incidents of as well as if you're in the design business, you have errors and emissions insurance, which is separately typically held by design professionals. So these policies typically pay for attorney's fees in your defense of a claim. So there's an additional concern for me as a retired contractor, because you still have that ongoing exposure from your past jobs that you have, even though you're retired. And you can get some insurance, which is called a tail policy, which will give you a certain amount of liability coverage for a period of time, but it's very expensive, about $35,000 a year. And there's a maximum time that you can have that insurance. It's usually about 3 years. So with an unlimited statute of repose, that's for as a retired person, I have a personal exposure potential indefinitely at this point. I understand that I'm in the business. I do have a responsibility for what is reasonable if I made a mistake, but for it to be indefinite, that doesn't seem to be fair. And yeah, and if you have to defend yourself, whether the case has merit or not, it gets expensive. You have to pay for your defense, and you have to spend the time to do it. And even if it's dismissed, as Matt, what she knows from Truex. So just looking for consideration in the big picture to help you with your overall decision on what's best for the bill going forward. But I appreciate you allowing me to share my story and take that into consideration. Thank you.
Great. Well, thank you. So questions, Angela and then Karen.
Hi, thanks for coming in. I'm curious if you can just say a little bit about how, I believe you said that this is the one time that you've been sued.
Right.
Are there other examples of times when homeowners have noticed some sort of flaw in design or build that you did address, that you also recognized and needed to address?
Yes. No, I think that you're learning things as you go. Sometimes, especially as a younger company, and sometimes you use different materials that don't work out as you had planned. We have a really severe climate, so things sometimes can prematurely fail. So our policy was always, if it was something that we felt that we did, that we would stand behind it with our clients.
And do you and your clients have a signed contract generally?
We do, yes.
And is that policy in the contract?
We have a written 1-year warranty,
Okay.
but we have so that's, I guess you have a written versus express warranty. So we always tell people that we always take care of issues. We have 1-year warranty, but if things come up, you can ask any of our clients that we stand behind it, and that's our reputation out there. That takes care of their clients.
Thank you.
Welcome.
Sure.
Yes, so thank you for bringing up the insurance piece. I feel like that's a piece that I hadn't thought through. And so two questions on that is curious, maybe you know this, maybe you don't, and maybe we can find somebody. I'm curious if Vermont insurance rates for Vermont contractors, designers, I don't know terminology, the folks that are involved in this are higher because there's no repose, because you're liable for forever. That's my first question. I don't know if you know anything to that, or if you when you were looking for insurance, if they said, "Oh, you're in Vermont, you have to pick this one."
I actually had a conversation with our insurance agent that asked something similar to that, and he said it's hard to know the impact of changing the repose, but currently your experience rating is what drives the cost. So they kind of look at all the losses that they've incurred in the state from their insured, and And that affects an experience rating, which determines the rates to make sure that they're covering all claims and making a profit at the end of the day.
And then my other question is, I heard you say that, which I think is an interesting piece, because you were retiring the business, and then now it sounds like you then sold it to.
To employees,
Yeah.
yes.
But you as a person, you're only able to get, I forget what you called the insurance.
It's a tail policy,
Tail
tail
policy.
liability policy.
That only goes for a certain number of years. You can't get that for the rest of your life.
Exactly.
So then you have to have
You have to-
personal insurance or something, or you just pay for it.
Exactly.
Are there policies that do last forever? And, or no?
No,
They only,
none that I'm aware of.
thank you. That's helpful.
So, any, have you had a chance to read the language of the bill, I assume? I'm just wondering, back to the earlier question we had regarding substantial completion date. And I'm just looking at the language and wondering at the last sentence in subsection C. I don't know does somebody have that? If that makes sense. We had some confusion about how that read.
And I just struck out the limitation to repose just so it matches, but
Right, period.
And I guess what would be an example of a phased project?
that was kind of Karen's question.
Yeah, I have no idea.
Right, because typically you have a one project. What if it's phased? It's going to, you may have phase two. It's got a separate project. It's not like a one project that's phased. It's combined.
This isn't really how this works. No, I mean, it's what it sounds.
Unless you have an example that contradicts that, and that's my experience.
I feel like I'm thinking about developers who build large scale residential
Right.
projects, and this building is phase one, this building is phase two, so I think
But
that's.
would those be independent contracts or separate contracts?
I would think that you would have, you would have, if a developer was building it, typically the developer is selling the homes to a homeowner who has the developer has a contract with that homeowner, they would have that same substantial completion process. So if you had a multiple home development, your particular home was the only one that has this issue, you'd have a contract with a substantial completion, which would start the statute of repose.
Yeah, I guess I'm thinking of a development of like apartment buildings, where there's not a single homeowner, and that's how that works. I think
Yeah, well.
Sarah might have something to say.
Oh, we'll have you testified. Are you available to testify after?
I can jump into
Identify yourself in the record.
perhaps, yes, for the record, Sarah Mearhoff with the Associated General Contractors of Vermont. There are, so large multifamily homes are certainly the kind of circumstance that I think you're thinking of. And I've had members who have built large apartment buildings and moved people in phases while construction is still ongoing, or I think you all know the Burlington project where there are two towers and one's complete, one is still ongoing. I'd be happy to run this language by those members who are developers and they can come in and
Right.
would be happy to clarify
Okay, great.
or, help tweak the language.
Yeah, if you could suggest a witness on that. That would be great.
Absolutely.
Thank you. All right, yes.
So I think one thing that is important to us, or at least I can speak for myself, is, and I've been involved with managing projects at nonprofits, have been phases.
Right.
Really familiar with tail insurance from a human service delivery standpoint, and know how pricey and hard those are to get. So I appreciate everything that you're saying. I think the bottom line is, what do we think it would look like for, again, we need these protections for the architects and contractors. For the consumer or the customer, what do you think is could be different? Like, will customers, consumers, whatever, be losing something if we move to this? That you, I mean, it's just, I guess it's just good to hear like
Right.
what, from your standpoint, you think that would be like, not from your viewpoint.
I guess you would be losing an unlimited ability to go back on a project. You would have to be comfortable that whatever the time period that was determined was fair and reasonable, and that you had the trust that you're working with somebody who's reputable and who's going to stand behind what they're doing, and they're not going to have issues within that period of time. And if they do, they're going to take care of it.
So sort of having consumer protections that we put in place for contractors, and the list that we have of like people who have done like the fraudulent, I'm trying to think what the name of that list is, but like somebody comes and they collect money to have driveways paved and then they don't do the work. I know the AG's office has been trying to do consumer education.
Right.
So, and I'm curious, when you talked about the current homeowner going to court to assume the contract, do you know if that happens frequently? Like that seems odd, and I don't know if that
Right.
homeowner, the new homeowner, like if the court just ordered it and it's like, okay, there's nothing that can be done, like it seems like a quirky avenue to go down.
I think that's just in the technicality of the law that it's allowed. I think that you can potentially address that in your contract if you write it specifically that the contract can't be assigned, which we didn't do. But I think if you knew that up front, that may have made that not possible to do.
Which is sort of the norm, right? Like I know I have a lifetime warranty water heater, but apparently that was the former owners that have that, not, yeah. So are you aware from your colleagues, like, is that kind of happening a lot? Like that people are going in and trying to go after mistakes? Like technology changes. My house was built in 1964 and it is it's so quirky for today's standards. Like I wouldn't even think of going back to suing the architect.
Right. I think that reputable companies with a good reputation, typically you're in good hands, so they're going to take care of things. Maybe it's more the less reputable companies that you have issues with. And in that case, you're probably less likely to recover anything anyway in the long run because you don't have the assets to attach.
And there are like you're certified as like you could get a Better Business Bureau rating, right? Like for your company.
Right. Well, there was, I don't know how that was introduced, but I know there's a process through the state where you can have it be a registered contractor. That's a recent bill that came through, and that's a good start. Companies who are actually registering this, they're more professional than companies that aren't registering. And I think that you have some backup as far as references and information about those companies that are registered.
So that could be a good, if this becomes law, like that would be a good thing to make sure people know to do that.
Right.
Which makes sense to do anyway, but yes.
Right.
Thank you.
Welcome.
Okay.
Yes, thank you. Another question.
Sure.
So we are going from 0 years of proposed to this is proposing 6 years for it. Yesterday, our legislative council shared a chart with us of all other states and what they have. And so in reviewing that, it looks like 6 tends to be kind of towards the lower end. And so for me, I think going from 0, like I would want to maybe give more of a buffer, maybe go with 10, something higher.
Mm-hmm.
Why is 6 the right number for you? Or what do you think is the right number?
less than none. And I realize that states have all different numbers, and it's 6 to 10 is probably the where other states are. So
Okay.
what's fair for us, I guess, is a matter of debate and compromise to come up with the best spot to be.
Thank you. I just appreciate that. Like, I think it's important for us to use data and stuff, and also take into balance the fact that we're at zero now. And so where is that line? So thank you for that.
Questions? Just one more, could you expand a little bit more on the alternative if there's is a statute of repose as far as homeowner responsibility? You just mentioned that very briefly in your testimony. If you could kind of expand a little bit on that.
Well, I think it's taking care of your home is like taking care of a car. You can't just ignore the maintenance. I think you have to have, a well-organized homeowner is going to have maybe a spreadsheet with a maintenance plan that I've got to paint every 5 years or 8 years. I need to pump the septic tank every 3 years. I need to clean the boiler every 1 year. I should do an annual walk around the house just to make sure that I'm not seeing any sign of decay, and if it is, making sure that that's addressed. Knowing the longevity of your roof shingles, if you have a 25-year roof shingle, kind of keeping an eye on that. Checking chimney flashings and chimney caps to make sure that those are intact and well maintained.
I should be writing all this down.
Yeah.
I'm apparently not.
Yeah, these are all, once you build a home, it's you can't just leave it. I know we live in a severe climate with extreme weather, and it needs constant attention to be well maintained.
So the projects you did in the past where somebody called and there was an issue and you went out and took care of the issue, what were the timelines on those? I mean, was it 6 months after, 15 years after, or I guess what I'm asking is were they all under 6 years? It would be real interesting to me, but then you might not be able to remember all of them. I don't like that. I guess what were the timelines as far as once the substantial piece was done up until somebody called?
I think most of those are within a year or two, and you usually see something fairly quickly. When you get out further than that, I think sometimes it's a little bit blurred. If it's kind of what was the cause of it? Was it neglect, or was it a bad detailing or a poor choice of materials? But we've come back and we don't if there's some ambiguity, we'll just take care of it. So we've taken care of things 6-7 years after the fact as well.
Yeah. So from the sounds of it, then it's, for you anyway, your company, 6 years would cover almost everything.
Right.
Other questions? Yeah, go ahead.
Has there been an example in your time in this industry where you've had a defect that you have discovered after 6 years?
Not that I can think of, no.
Yeah.
The one that you're dealing with right now is 17 years, 18 years ago, something to that effect, right?
Yeah. And I guess right, in that case, ultimately there's the question is really what is the cause of the damage, and the protection you have is in that way is that they have to show, and there's a ton of time and all that stuff. But your point's well taken that it's costing you thousands of dollars in attorney's fees to protect yourself. And so, yeah, the balance there is real. So.
All right, thank you very much. And we'll have Matt join us next.
Great.
Thank you.
Thank you.
Thank you all. I appreciate it.
Yeah.
Thank you for being here. Identify yourself for the record and proceed with that.
Sure. Thank you for having me. My name is Matt Bushy. I am the managing principal of Truex Collins Architects in Burlington. I am a licensed architect in Vermont and 4 other states. I have been with Truex Collins for just about 20 years. It'll be 20 years this spring. I started in 2006. I have been a partial owner or an owner for a little bit less than half of that time. I have a few partners. I have a few partners that work with me, and they're all about my age. I'm 52. So in a sense, we are the kind of 3rd generation of ownership of Truex Collins. The firm was founded in 1968. Some of you may know or may remember Bill Truex, who was the man behind the Church Street Marketplace. So we were founded in 1968, which makes Truex Collins one of the oldest, not the oldest, but one of the older architecture firms in the state. We have 30 staff, architects, interior designers, and administrative staff. So with 30 people, that makes us, I think, one of the larger architecture firms in the state. Although I think at that size, we still think of ourselves as a small business. Liability insurance is one of our biggest expenses. After payroll, we pay an annual premium of $90,000 for our liability insurance, which is a big number for us. To try to keep those costs low, we have a very high deductible.
How much is that? I'm sorry.
So our premium is $90,000 a year for liability insurance.
And how many dollars does that cover for
That's
liability?
That is a $5 million policy. So because of the work we do with large clients like UVM, they require $5 million of liability insurance coverage. So reducing our coverage is not an option for us.
Okay, thank you.
Yeah. But so to keep the cost low as we can, we have a very high deductible. So we have a deductible of $75,000 per claim or $225,000 per year. And we have never reached those numbers. But what it means is that these cases that we're talking about, like today, are expenses that have to come out of our pocket. So we have had to deal with, I think, 3 or 4 legal situations in the past 10 years or so. And they were all, I believe they were all related to projects that were before my time. And they were all either dismissed or dropped or settled or, we were not found guilty or liable in any of those situations, but yet they still incurred costs and time and were a real drag on the firm. So that's a little bit of background with the insurance thing. So talking a little bit about this case, I won't repeat a lot of what Tim said, but just cover the basics. We were hired, the firm was hired to design an addition to this house on Grand Isle in 2002. And as Tim said, it was constructed in 2003. 18 years later, in 2020, a new owner bought the property. And these are folks who are California residents. That's their primary home. This is their second, or at least their second home. And they discovered water in the kitchen ceiling, as Tim described. The new owner is not a lawyer, but he has some amount of legal training. So he was representing himself. He acted as his own attorney. He filed suit against the original owners, and then he filed suit against Peregrine and Truex Collins as co-defendants. Let's see. So there was leaking above the kitchen ceiling. There was a roof deck above. The claim against Truex Collins was not that our design was faulty. It was not that our details were wrong. The claim was actually that the the work wasn't carried out according to the drawings, and we failed to catch it. That was basically the claim against us, which has no merit for a number of reasons, which we paid our lawyer to get into. So they filed a claim against Truex Collins for about $270,000, plus punitive damages, plus attorney's fees. So like I said, the claim did not say that our details were at fault. So I was not personally involved in this project. I started at the firm in 2006, and this project was complete in 2003. So I have no direct experience with this project. Partner in charge of the project was Bill Truex. Bill passed away in 2022. So there's that. The architect who worked under Bill on the project retired from the firm in 2008. He still lives in town, but he has not been with the firm for a number of years. This whole thing stretched out longer than I ever expected it would. I would have thought that we could have just filed a motion and laid out these facts and that it would be dismissed, but as you all know, justice travels slowly. Basically, it was a period of almost a year from the time that we received the summons to when ultimately the plaintiff dropped the case against us. And over that time, we incurred about $35,000 in attorney's fees. So it started in the summer of 2024 when we received the complaint. We filed a response to the complaint. The case entered into discovery. We responded to the plaintiff's set of interrogatories, which included requests for us to produce all the material related to the project, including drawings, contracts, correspondence. Now, this is 20 years ago, so we had to kind of dig into our archives. Nobody in the office had worked on the project, so that took time and resources. We actually, over the past number of years, we have maintained 2 offsite storage units, which we rent in South Burlington, which are chock full of blueprints that are 30, 40, and 50 years old, because we can't get rid of the stuff. So let's see. Our attorney reached out to the 2 living former employees who worked on the project. And our attorney entered into depositions with the plaintiff. The plaintiff was going. The plaintiff offered a settlement offer of $75,000 and asked to schedule a mediation. And that puts us into a really tough spot because we were not at fault. And so you have to weigh paying a settlement offer that you know you're not at fault for versus the costs of the attorney's fees. And so we kind of grappled with that we ultimately did offer a small settlement offer, which they rejected. So then it was looking like it was going to go to mediation. We had to retain a local architect to act as an expert witness in preparation for mediation. We filed a motion for summary judgment in March of 2025 with a number of reasons why we believe this claim against us should not stand. Some of them were technical reasons, and some of them were kind of practical reasons. For example, I said that the argument against us was that we didn't catch the fault of the installation on site, but we produced an email from the client in which they asked us not to come to the site anymore, which happens sometimes. Sometimes architects are hired to do the drawings, and the owner says, "We don't need you to observe the construction. We can take it from here." And apparently, that's what happened here. So that's just one of a list of reasons why we believe this case didn't stand.
Did you say there was documentation for that?
Yes, there's an email from the client to us, the architect, saying, please don't come to the site anymore. We don't need you anymore. We're good. So when the court read this motion for summary judgment, actually, no, what happened was when the plaintiff read the motion for summary judgment, they decided to drop the claim against us. So that's how it ended for us.
Can you tell us how much you spent on legal fees and?
It was about 35,000,
Say again?
35,000, which is about, half of our deductible.
Right.
But you also had other, I'll call them administrative fees with people doing the searching for
Sure.
documents and
Yeah,
all that. So
yeah. I spent a fair amount of time on it myself. That we never tracked that, but certainly that was an expense.
You could, to me, you could include a portion of the storage unit fees too, because it's all cost because.
Yeah.
Maybe I missed it, but do you do the whole contract or do you have any contractors involved in?
For the architectural design, I don't believe this contract would have had sub-consultants. But
So you're the actual designer.
we're the
Somebody
architects.
else will then take that.
Right.
Design that had maybe the flaw. Is
Right. If we had detailed the roof incorrectly, for example, which we didn't do, but yeah, we're the architectural designers in it.
Are you contracted by a general contractor?
No, by the owner.
I don't know if you have more to share. I can hold my question.
No, it's
So it's the same question I asked, previous person. Why 6 years? Excuse me. It seems like 10 could have addressed this situation. And so I'm just trying to think if there's a conversation. We haven't yet heard from somebody that's saying that we should push it out more, but so far I'm not hearing an argument of why it has to be 6. So that's what I'm trying to understand. Is there room for it? I mean, we're at 0 now.
Yeah, I'm not sure where the number 6 came from. It makes sense to me, but it's not the main. I think it could be a different number.
We could be fine with 4 too, but we could be like 14, like, so it could be all over. Yeah, right.
Same question I asked the other witness. Do you have any examples of defects that you've discovered in designs that you've done after 6 years?
So typically for the design side of this, if there are errors and omissions is the term, those would be discovered during construction.
Yeah.
And a design solution would be developed during construction. And there may be a change order during construction. And there may be a dispute who owes money for that change order for that expense. But I can't think of that happening after the project is done.
Yeah. And then but you could be sued for the construction side of it, which is what happened here, I guess. So are there any examples of like after the design is implemented, have there been discovered defects set more than 6 years out that you guys had to correct?
I mean, like I said, there were 3 or 4. This was one of them for the past 10 years, but in all those cases, we weren't found to be at fault. So I guess the answer is no. Things that come up, but in our experience, they didn't result in us being found by negligent.
Yeah, but yeah, so things have come up, but they've resolved in some way, mediated or
Like this one did.
but
Yeah, Angel.
I guess a sort of a I want to ask the same question that I asked earlier about your general practice and policy, both practice and policy, I guess, for when defects are found, that things that don't end up in a lawsuit. Just to get a sense of, or contemplating the idea of sort of restricting protections for consumers. I'm curious to know what your general policy, what your policy is for protecting consumers.
So we have different kinds of contracts and agreements with different clients, depending on what they would like to do. Sometimes we use an AIA contract. And sometimes for residential work, it's a simpler agreement with a client if it's a small project. We have some language that in our agreement that defines errors and omissions, which is a standard term in the industry because we are not perfect, and it kind of defines that there may be an amount that is like 3 to 5% of a contract that could be measured as potential errors and omissions. So in other words, if there is a mistake in the design that leads to a cost, if those costs start to get higher than a certain amount, then we pay for it. So there's that. We also have language in our standard terms and conditions. If a client decides not to engage us for construction administration, there's some language that explains we cannot oversee construction or provide not inspections, but oversee construction to ensure that it's done per the design intent. We can't do that if we're not hired to do that. So there's some language in there that defines that for the client.
That's helpful. Thank you.
So you're in 4 states.
I personally am licensed in Vermont and 4 other states.
Do you do design in those states as well?
We do work in multiple states.
Is your insurance policy kind of cover all of that, or do you have separate insurance for those states?
No, it's one policy.
And do you get sort of a sense of, I'm assuming those states have some sort of protective law like this.
Can you tell us what states you operate in? Actually,
Well, we for the firm to do work in state, at least one person in the firm has to be licensed. And so I'm licensed in 4 states, but there are other people in my firm that are licensed in other states. But we do work in New Hampshire, all across New England, a lot of work in Jackson, Wyoming, Florida. There's certain areas that we do work in.
Yeah. Does has it kind of the laws in those states and kind of protective statute of limitation things, like have you seen an impact on kind of like how you've done work in those states versus how you've done work in Vermont?
I mean, most of our architectural work is in Vermont. Some of the work that we do in other states, we also are an interior design firm. So some of the work that we do in other states is not, we are not the architect of record for, but I agree with Tim's response to this train of thought, which is that I think our insurance rates are based on our past kind of experience and our past, the amount of kind of legal expenses that have incurred, et cetera. So I think that a statute to propose may not have a direct effect on the rates, but I could certainly expect it to have at least an indirect effect. In other words, if there was a statute to propose, this case may never have been filed against us, or at least it would have not lasted a year and incurred so much costs. And so if that were to happen a number of times, I could expect that our rates would go down because our risk would go down. Does that make that,
Yeah,
that
yeah.
answer your question?
No, I think it does. Yeah.
I think you got it, but more clear for me, I guess. If a state has a lot more claims than say another, does your insurance agent calculate that into your thing? If you're operating in that state?
I don't know specifics of how they calculate the rate.
So you mentioned 3 cases that have come up in your time that they were older cases. Did they involve personal injury or property damage?
I don't know the specifics of all of them because again, they were before my time, but I think one of them was another roof issue. And I think there was one where there was someone fell on a sidewalk and we were somehow involved. I know that they were all dismissed or settled, or we were not found liable, but I don't know the details.
Okay. Thanks. Any other questions? Not seeing. Thank you very much for being here as well. Really
Yeah.
appreciate it. So we'll go to Michael Goodrich, who is joining us by Zoom. Thank you for joining us, and thank you for your flexibility and being able to be available in such short notice. Really appreciate it. So if you could
Good morning.
identify yourself for the record and proceed.
Yes, my name is Michael Goodrich. I'm the owner of Michael Goodrich Custom Builder in Norwich, Vermont. I've been a builder for 40 years, and my grandfather was a builder before me. I'm a lifelong Vermonter. This is in our blood, and I've been working in the Upper Valley in Hanover, New Hampshire, Norwich, Vermont, primarily for the last 40 years. It's been a great living. I want to thank Rebecca Holcomb for mentioning that this is a very good item to have. The statute of repose is very useful. And the reason I asked her to look into this is I had built a house in New Hampshire in 1998. And I ended up doing a remodel on this house in 2001, and then a second remodel in 2015. And the client talked to me in 2015 about her Pella doors, which had a 10-year warranty, which were installed 14 years earlier, and Pella would not warranty the doors. Okay, so, okay, fine. It came to be 2022, 7 years after I did the remodel in 2015, and she had sent me an email about the doors again. So she would like to replace these doors, which are no longer covered under warranty, and can you replace the doors? And I said that was a possibility. Let's figure that out. In the next couple of years, I kind of ran out of time, and I did not install. I didn't even address the project. I was too busy. And she had another builder come in, and he removed a door, and he noticed there was a little bit of a tiny leak up above. And we started looking into the thing. It was a tiny piece of flashing that was missing from our 2015 job. This was discovered in 2025, 10 years later. So I've never had an insurance issue until this issue where her insurance wouldn't cover it because it was a defect. So her homeowner's insurance didn't cover it. And my insurance wouldn't cover it because it was beyond the statute of repose in New Hampshire. So I looked into it more. We pursued it with my insurance company, and they said, well, actually, she contacted you about these doors 3 years ago. That's within the statute of repose in New Hampshire. So we're going to pay for it. You're liable for it. And we did, and they fixed it. And so as I'm thinking about this, I was shocked to find out that Vermont had no statute of repose. And without a statute of repose, I could be paying for this well into my retirement, as the other fellow suggested. To have never, I'm a small time builder. We do 2 houses a year with 3 or 4 remodels. And we have $1 million of liability that we pay for. And I'm planning on retiring in the next couple of years. As we've discussed here, it would be shocking what my insurance bills would become if I retire. But anyway, I'm still planning on doing this. One of the interesting things that came up about this issue is when the defect was discovered, I only keep tax records and my clients' records for 7 years for tax reasons. So I'd thrown away all my tax records. So I didn't have any information about who even did the siding on this job in 2015. It's just not something that's in my focus. The doors were warranted for 10 years, which makes sense. That's Pella's idea of a long warranty. Our cars are warranted for 3 years. It makes sense to create a finite opportunity. So one thing that I've heard a couple of times is the statute of repose in Vermont right now is 0 years. I want to correct you. It's infinity years right now. There's no limit to the statute in Vermont right now. And, the statute would help homeowners by providing a clear and final deadline to discover defects and create a reasonable time frame to contact the contractor and have him repair stuff. As the other gentleman, I have also always come to my client's aid. I've always helped people get through any issues, any sort of rot, anything that happens. I do it for a long, long time. To have it 6 years, that's great. I've always done it pro bono. I've always fixed stuff that I've built. My interesting thing is even medical malpractice statute has a limit of 7 years. So if, for example, someone dies because of what I did as a doctor, 7 years is all you get. No one's going to die because the flashing was incomplete on my house in Hanover, New Hampshire. But, I understand the logic here. Any questions?
Questions? I'm not seeing any. That's very helpful. I appreciate your testimony. So, but I guess we have been kicking around what we should do as far as time. And you mentioned that New Hampshire had 8 years.
Yes.
And do you have any opinion of that? Because my quick research into what was sent by your legislative council is it is even in New England kind of all over the place. It's 10 years in Ireland, 8 years in New Hampshire, 6 in Massachusetts and Maine, and 7 years in Connecticut. Any opinion on what's a good number, or any basis, I guess, for us to look at what the right number should be? You mentioned the Pella, the warranty, 10 years. Is that a kind of a common standard for the materials that are put into homes? We heard that there's a 1-year kind of warranty that I think one of the earlier witnesses mentioned. And I'm trying to attach, other than just picking it out of the air, an appropriate time frame.
I would say I agree with the other gentleman that most every issue has always come up within a couple of years, within a year. And I've always given my clients, I've always come back for the first year with no question. I always come back anyway. It's a small town. I do everything here locally. I volunteer. I'm part of this place, and we've been part of this place for years. So I've always taken care of people around here. But somebody sells a house to someone else 12 years from now, and jeepers, that flashing doesn't look right to me. Goodrich has to fix it. Well, jeepers, that doesn't really make sense. I do like the idea of, I was delighted to see the number as 6 years. That's a great number. Most everything has happened by then. In my case, in New Hampshire, it was 7 years that the defect was found, or that was actually talked about something that was unrelated, but it was 7 years notification. So I don't have a good answer, but I think that the client does have responsibility in maintaining their house. So if I've allowed the paint to peel off in certain areas near windows, there are responsibilities to take care of this. And if you have a 6-year timeline, the client will be more active in thinking about that number. It's very important to have a strict timeline. regardless what the number is, to make sure the clients can address their needs with their builder before it expires.
I appreciate that.
Yeah, not really a question. I went through the literature we have with all the timelines on it and added up. I got an average for the country. Full transparency, I dropped the high number and the low number, and it just makes for a better average when you do that with numbers. But then I came up with an average in the country, which at 8.365. And
Here's your number.
So other than following one state or just New England, and I mean, and the numbers are like Representative Dolan was saying, the numbers are all over the place. I mean, there's 4s and 5s and 6s and 10s and 12s and I don't know.
I think we have the opportunity
I
here.
think that's a fair number just because it's average of the country. I would like to see it stay at 6 myself, but I don't think it's going to stay there.
I think we have an opportunity to stay better than the state of New Hampshire here.
Yeah.
There we go.
So it's kind of interesting. I guess the top of the table here has similar thoughts because I added up things and did an average, but I did New England. And for New England, it was 7.4. So we have, two things.
I like that.
Yeah. So
Split that.
right. So it may to have some sort of basis. We can do either 7 or 8 years. So,
If I may add, Chair,
yeah, go ahead.
so New York, who's right next to us, I think has 0.
That has 0. I didn't
Infinity.
count. I didn't count.
I'm just putting that out there. In
Infinity.
many ways, it can be calculated.
And
Yes.
absolutely.
Come up with your own suggestion.
I could see also there's something to 6 being like the search standard statute of limitation in Vermont being 6 years. That like, so you're just like thinking like, okay, yeah,
Like that.
but
Yeah, there's there'll be further discussion on it. I'm sure we can have some additional witnesses as well. Thank you very much, Michael, for joining us. I appreciate it. And thank you to the other witnesses as well. Committee, I think would like to have input from you folks on who else we might want to hear from, whether we want to continue working on this bill. I'm kind of gathering from what the questions were that we probably do. And if you have suggestions on witnesses, let me know and we'll try to schedule some additional folks. So we're adjourned until 1 o'clock. We'll have some additional witnesses. So
Thank you so much. And thank you to Rebecca Holcomb too.